All right, good evening, everyone, and welcome to the Legal Contracts and Board Policy Committee meeting this Monday, April the 21st. Thank you. We will start by having our viewing of our previous board minutes. Are there any questions or concerns we have or changes, corrections need to be made on the minutes?
Chair, I make a motion that we accept these minutes as is.
Okay. Thank you. Minutes are accepted. Next, we have any public participation. Anyone to address the board? Anyone to address the committee? I'm sorry, I said board, the committee. Anyone to address the committee? No one to address the committee? Okay, we'll move on to our topics of discussion. We'll start with Ms. Carter.
Okay, back on for discussion, and the committee met, and we feel as though the nepotism policy may be ready to now move towards a first read unless anyone on the committee sees any other updates or changes that need to be made. We were looking at it to fit under conflict of interest because we would have to assign it a number. And we would just have it fit under each area that addresses, each policy that addresses conflict of interest with the .01, .01, basically whatever number is next available under conflict of interest.
Thank you, Ms. Carter. Any questions?
I'm just trying to clarify. So are we doing, will this be a new policy or this is an addendum to each of these?
Oh, no, it's a new policy, but it will live in the area of where the conflict of interest. So a lot of our policies are like 4113, and then it'll be 4113.01. So that's where we would put the nepotism policy.
Okay.
Any other questions, concerns in reference to this policy? If not, we'll move on. Next, Ms. Carter.
Next is the vendor relations policy. And is Ms. Folk in here? Oh, okay. If you could come up and just talk about the vendor relations policy. There were only like a few grammatical changes as relates to some of the pronouns that were being used. You can see some of the things in black as relates to the changes that were made, and I'm going to let Mrs. Folk do an overview.
The vendor relations policy is a long existing policy, and Neola did come up with some grammaticals, such as the first one you see, which is in 2, and they changed it from he, she to persons. The second last 2 lines of the first paragraph are an addition by us that we felt were important to add, which basically says previously that an author, if I was writing educational materials, we wanted to make sure they were properly approved to be in the schools by the district. We added the following: providing the authored educational materials were not created during the employment with the district or created using board materials and funding associated with the district. This was something that did come up previously. We had a grant provided to the district. We had some very crafty, wonderful teachers who made a curriculum, and we found it was on the webs outside the district for sale. So we want to make sure that if that occurs, that the intellectual property rights remains with the district because it was using funds either awarded to or provided by the district. So that's a new addition to the policy on behalf of the district. Then as you go down, you will see some of the other areas that it went from his and her to either they or their, which was not it was a grammatical update. Now, the salespersons, regardless of the product, the word "the" was added, shall make contact with the superintendents. So these were Neola updates to make sure that the legal issue was appropriately addressed. The next section of this is the requirements for certain technology provider contracts. And this came into play when the state of Ohio made their changes, and Haley, I always say it wrong, it was Senate bill, not House bill. Am I correct?
129, I think.
129? Yes. Last time we were here reviewing this, I said House bill, and I wanted to correct it. So these are items that come legally to our attention through Neola because of Senate Bill 129. And these were vetted by our technology department. And as you can read it, we have very specific conditions we must now meet as we would do different technology provider contracts. Most of this is data exchange. And I'll give you an example. Sometimes when we're doing testing or we're doing data transfers back and forth, we want to make sure that the data transfer is not only correct for the vendor and us, but it is housed and secured properly. And that's what Senate Bill 29 really talked about, as to how to make sure it is secured if there were breaches to it, et cetera. But we had to make sure that it also met the federal statutes as well. All the contracts between the district and the technology must ensure the appropriate industry-recognized security measures, which I just discussed. And this also was vetted through our technology team, as well as Dr. Hodo has seen it as part of our new communications and technology person. And by August 1st of each school year, the district will provide to parents, students with direct and timely notice by mail, electronic mail, or other method of direct communications of any of the contracts the district has with any of the providers of these curriculum testing and assessments. And we've been going down this road for quite a while. So we just are, it's more of cleaning up items to meet the actual drafting notice that came out from Senate Bill 129. All righty. And then Senate Bill 29 was its drafting notice is what came out of the 135th General Assembly, and it took effect in October 24th of 2024. So we wanted to make sure you understood that as well. And then the criminal background checks was just an area that was added to this. It was a change in title only, and it also relates to the Family Educational Rights and Privacy Act. That was a new add to the bottom so that we can follow exactly how this works. Any other questions?
Any questions? Madam President?
Thank you, Chair. Yes, I have a problem with these last two lines that you added concerning the teacher's intellectual property. Mm-hmm. And I understand what you're saying, and I just don't agree with what you're saying, because if a teacher has a certain expertise and he or she is hired to teach science, that's fine. And if a grant is provided where they get additional information on science or to provide something, their ingenuity of creating a curriculum, developing a curriculum that is their intellectual property. I understand how you worded this as if it's because of the district secured grant that they were able to develop.
And they actually developed it while they were on duty during being paid. So it came out twofold. They didn't do it offline on their own time. They did it as part of their workday and used the funds of the district. So if I stated it incorrectly, I apologize.
No, I just know that some of this, even within a workday, because of the very tasks that they have to do, that they're doing some of this work outside of work hours. And so I just think, were there any teachers at the table to kind of unpack this?
This was something that we brought up in the review of the policy. I will not ask. I don't know who else would have been contacted. I'm sorry, I can't address that.
No, it's all right. Because people are coming up with like retirement plans, and they are coming up with excellent curriculum or innovative things, and I'm just not a fan of them not able to be compensated, or because you said once you saw that they were selling it on another website, materials that they created, and it was seen for sale on another website, then the hindsight was, we need to do this.
Actually, legal at the time wrote a legal in-house counsel at the time wrote a cease and desist letter to advise them that they could not do this, and this is the first time that Neola has brought an update to 6460.
So if it wasn't already a policy, how did they get a C&D?
Because our legal counsel in-house at that time felt that they should be advised that what they had done on time and using district funds was inappropriate to be able to sell and make profit of it. Maybe it's another way to vet it. I would rely on Haley to maybe make it better than I am, but
No, because Barbie, Mattel does this. A lot organizations do it. I'm just, it irritates me. Because then what can happen is if I'm a teacher, okay, I'll do, because I can teach science and I can come up with something creative, but the extra hours that I know as an educator, on top of what they have to do on their work hours to develop a full curriculum, is going outside of the scope of their daily hours. And to really understand how could this be advantageous for district and for the employee, the teacher, whose intellectual property it truly is, and because they're not getting. Are they getting additional funds from the grant? Are they getting additional payment on top of the grant? Or is it a grant and they're provided the funds to create the curriculum? Or are they getting paid as well on top of their original salary?
they got their salary payment and they got the materials and supplies from the grant funds to actually do the writing and the materials.
And that's my problem. Because then that's the job. You're providing me materials, but I'm not getting paid for my work, my mental capacity, bandwidth, any of that. Y'all providing the materials like if you provide me with crayons or something from the art room. But my intellectual property, where I'm innovatively thinking of things, coming up with assessments and all different type of curriculum for students, and then the district owns it. I'm just going to put that out there because I just, at this point, want to be a voice for a classroom teacher that is going to be excited about getting a grant to help kids and create this dope, innovative, something fun that kids like, that they know, because I'm a teacher, and so I know how to relate to my colleagues in the profession. So you want this curriculum too? And then my district has me in the chokehold where I can't benefit from it. And I'm not getting paid, period. I'm just getting materials to buy the grant. So I'm gonna let that lay there because this is I'm one of set. This is my own issue, so I'm gonna let it go here at this moment. But I'm still processing because it seems like it needs to be some type of caveat where even if the teachers positive with the position, okay, you'll get the funds to do this. And the teachers can say, okay, this may take me 22 hours to develop this curriculum. And I'm a teacher. As a teacher, I'm like, I'll do this after hours. And I want to own my rights. I would commit as an educator. I would. And I know in order to own my intellectual property, okay, my contractual hours is from 7:30 to 4:30 p.m. And I won't work on it during that's what I'm saying, like, where any of these considerations made, before this is just, it would impact how I feel about this policy and how I would vote. But again, I'm 1 of 7. That don't mean it won't pass. But I just wanted to have this conversation because as an entrepreneur, as a person who develops curriculum, and you see people's intellectual property stolen from them all the time, and that could be part of their legacy and everything. It's something about this bothers me. When we talk about ingenuity and being innovative, and even for our students, when their intellectual property is robbed from them, what they come up with classrooms. So this is why my mind is going to how can we better serve all parties where we all win. Not saying, I'm going to say where everyone wins.
The Be Kind event that resulted in the poetry book, remember that event that was at the Civic? There was an actual agreement that legal helped put together where the students retained their intellectual property rights, but the publisher could go ahead and publish the book. So those were some of the other things to your point about exactly who owns what. It was just a way to understand how we would use our dedicated funds that are expended through our district.
Okay. Thank you, Ms. Fogg, and thank you, Mr. Chair.
You're welcome. Mr. Harrison?
Thank you, Mr. Chair. One of the things, and you hit it at the end, I think the law really dictates who owns the property. However, the district can release the intellectual property to the teacher if that's an agreement with both parties. But the law says if you create it on salary, on duty, using this, it belongs to the district. But the district can release that intellectual property in some cases. So I think that's a consideration, because I know you're talking Cadillac Records here, the Funk Brothers. When we're looking at the vendor relations, and I see we added some stuff to the policy, do we have a clear policy or clear, when a vendor has some type of issue, do we have a clear path of dispute resolution?
It depends on the contract, and sometimes the contract actually gives you an idea how you are allowed to dispute or rectify, and it's called cure legally, and Haley knows this better than I do. It often is something that could be cured easily by just talking it through. It
Right.
could be also a cure that is through a mediation or an arbitration. It depends on the actual contract with the vendor. And some are very specifically vetted. That's why we have legal look at those contracts.
Yeah, and I understand some just are boilerplate information in the contracts, and those are usually larger contracts that are getting into a lot of money. But if we're talking about just let's say the IC, the van, independent van contractors, So we're talking about the van drivers, or we're talking about someone who supplies, let's say, hot dog buns or something. I mean, something that's not large enough that the vendor would have to secure legal, we would have to secure legal, but just a process where if someone comes to us and say, hey, we've been treated unfairly, and we can just see, okay, well, you need to go this person, you need to do this, and then if that doesn't come, then you can come back to me.
Right, and as an example, we have certainly gone through the process with our legal department to vet any kind of notices to vendors that would be necessary to make sure that we are meeting those requirements. To your hot dog bun issue, sometimes it's just a matter of notifying the vendor that the hot dogs didn't come in fully baked, and they usually very often rectify them and give you credit for what is not usable,
Okay,
et cetera.
And I guess I'm talking about the vendors with APS. Do we have a process where the vendors can seek relief or dispute resolution with us?
So this is a question that I,
Sorry, go ahead.
oh, I'm sorry.
I'm sorry. Are you asking Ms. Carter?
She referred to
Okay.
it. So,
All right. Ms. Carter, go ahead.
So I had the same question as you, actually, as it relates to what would the process be. I know one answer that I received was, well, it wouldn't come through human capital or labor relations because they're not our employees. And so I was told to tell the person to write a letter to the department that they have the contract with. But other than that, that is it as it relates to them being able to explain their side of whatever the situation may be. But we don't have a process in Akron as it relates to how an individual person that may have a contract with us can dispute a termination of a contract other than going to court. So there's no internal process. They would have to go file something with the courts.
Yeah, and that would be if we're looking at these, if we're looking at updating policies or when some of the updates come from outside of the school, but if we're looking at vendor relations, we probably need a dispute resolution before it gets to the board. There probably should be some type where the vendor will know, okay, I followed this process. but there doesn't seem to be a process. And I think we kind of got into this last year, and we get stuck here. But we need to add some type of resolution to these
And it may
policies.
not be a policy, and I would defer this to Haley. It may be an administrative guideline to the policy.
I would like a policy.
And
Policy.
Haley can
When- okay,
advise on that.
Mr. Chair, and when we start talking about administrative guidelines, those administrative guidelines sometimes become subjective, and then they become arbitrary. Okay, and so the policy really doesn't give you that arbitrary application. So, you know, and I'm not saying that we should be the vetters, the board should be the vetters of the process, but there needs to be a process. There just needs to be a process.
Ms. Haley? Yep.
Yes, it's something that we can look into.
Yes. And if I'm correct, just make sure I'm correct too. Administrative guidelines are the step-by-steps of a policy, correct?
That is correct.
Okay, so with that administrative guideline is pertaining to the specific policy, hopefully it'll have a step-by-step saying what they're supposed to do. If it doesn't, then it is a problem, because it does come from the policy itself. And then, going at Pastor Harris?
Yeah, you have to have a policy.
Right.
Yeah, so
Yeah.
you have to have a policy to follow the administrative guidelines. And I guess that's the, I guess that's just, because we're updating this, you know, like President Jackson, you know, her line, okay, well, yeah, legally this is how it goes, but we can, in an administrative guideline, add a release. So say a teacher want to request, you know, a release. So that's the difference with me with the policies and administrative guidelines. Okay, the administrative guidelines should be some exceptions to the policies and to navigate the policy, but we still need the policy.
Okay. Any other discussion on that, Madam President?
I thought the vendor relations was the policy. That's the one thing. And so the administrative guidelines will go with this policy. Is that, because I had another part I was going to add. That's why I'm trying to get clarity.
Yes. Haley?
The vendor relations is the policy we're referencing, and the administrative guidelines that Folk reference would align with this policy if they exist.
Yes, that's correct. So the AG would be in reference to this policy.
Okay.
If that was the route that we ended up taking.
But I'm sorry, I didn't mean to cut you
No,
off.
it's all right. Go ahead. Thank
So I think the question is, because it doesn't seem that there's anything consistent like SOP, standard operating procedures, that should be under the administrative guidelines. It's just like with parent complaints, student complaints, where it hops over to where I know, like I as a board member, I think a lot of times we see the board getting entrenched into operational business, which we're not supposed to be into. But when you are an elected official and you part of a community, it kind of is almost like you forced into certain areas because when you're trying to follow policies or you're directing people to policies, if it's not a structured system. Like since I've been here, I've asked, because everyone know I'm student focused. So I'm asking questions like, okay, when students are referred to the board and I'm at church or I'm eating my salad and someone comes to me about this student being referred to the board and how they were done wrong, they're assuming referred to the board means they've seen us 7 in some capacity. And us 7 often don't have a clue about the issue or what happened. And so my question was a few years back that if there is a grievance process, you know, they go through principals, the principals go, like the executive leadership over principals, it's a whole structure, that there will be some form to where us as board members, we could see that, like it's like a report, not that we're responding to it. We can talk to our superintendent about it, but where we can see this is the allegation, a kindergarten through a tissue box at X school, and now they're being referred to where when we hear it on the streets, we can say we're already in front, we have some knowledge of it. And as far as the process, how the process is playing out, instead of as a board member on the tail end, when actions have been taken, we hear about it and we're like, well, yeah, that doesn't seem like it aligns with this this state mandate about kindergartners being suspended, or, it's like it get lost in the sauce. Or when vendors come and talk to us and they're saying, I wrote a letter, I did this, I did that, and person A told me this, and then when I did this, person A then told me something different, or they keep moving the finish line. So when I'm trying to cross the finish line, person A keep moving the finish line, and so where do I go? So then they end up on the mic. And then it's all and then Jen got to write about it. Then we got to go be at our luncheons in the community and people talking, what y'all doing down I'm being facetious, but you guys get it. And so y'all understand? So I understand the point, like what the clean-cut processes, not just all this vague circle talk is becoming a bit annoying. It's clear processes. So it's a standard operating procedure or not is what's being asked. And if not, then sketch something up, because I'm in year 4, and I asked about this for students, and it still don't exist. And every time comments come up like this, I bring it up again. So to Harrison's point, to everyone's point, a clear structure, even if it's aligned to the policy, that we can click and say, oh, it's a grievance about these drivers. We know it before they have to come down with signs at a board meeting, to where we can do the front work through our employee. Not getting in operations, telling our employee whatever, hey, what is this? Give us an update before the next board meeting, because if we can get resolution, that something clear like that is what I'm saying. So.
So just as a point of clarification, President Jackson, are you referring to kind of like a reporting structure that would be in an administrative guideline? Is that what you're envisioning? Okay. Yeah, that's certainly something we can look into.
Yes, thank you.
Thank you.
And just to add to that, President Jackson, I think this is what you're saying too, is, and correct me if I am wrong, we had talked about a whiteboard for board members so we can get these different things beforehand, and that way we would know, but we still haven't gotten a whiteboard. I know it's a lot of stuff that's been going on, but that whiteboard to help give board members that information so they know what's going on, they can follow the process. But we do also need to make sure that we always have a process, pecking order, for lack of better words, of here's the person should contact this person. If they don't get this person, who's the next person, and before they get to board. And I think and you guys have to correct me too about this here, I thought we had in a couple of our policies, or a definition of board, who the board is, and who the Board of Education administration was. And I don't know if that's still there or what. Someone will have to help me with that. But I know at one time we did have we identified who the board was and who the Board of Education was, but I don't know if it's still there or not. I haven't seen it, so somebody had to help me or look for that. Go ahead, Ms. Carter.
I know that in our, like when we have individual contracts, like for instance, our ICO contracts, those are definitions in there as relates to who do they mean when they say vendor, board, superintendent. So it talks about those definitions, but I will look up to see if we have those in our policies. And then we'll also make note that we want to put a procedure in place as relates to vendors when if they may have a concern or if they have a disagreement regarding some contractual issues.
Yes, I think that would help. It sounds like that's what everyone is saying. Is that correct, Madam
Because
President?
we don't have anything right now.
And for parents and students, not just if you're going to do it, just go on and do it. Mm-hmm. I guess I could have said that more professional. Let me take my time with my words. So if we're going to do this, Haley said this procedure for any grievances, so where it will be a general stop, vendors, click here. Student parent, click here. But it's a centralized system to where it goes to the various department, but the board can access it. Are you following me? Does that make sense?
It does make sense. It's something that, like I said, we'll have to look into it.
Excellent. I just wanted that is different. It's one for vendors, parents, students, something like that, and it can be even if names is not just scenarios or whatever, but so that we can see that. That's kind of what I'm saying.
Right,
Thank
and
you,
that should
Mr.
be
Chair.
part of our process period for everything. So every policy, everything that we do, we'll know what anyone will know what the procedure is. Who do I follow if I have a problem with a principal, or if I have a problem with administration? What about a contract, and who do I contact? So that's pretty much what you're saying. Yes, okay, thank you, Ms. Carter. You had something?
No, we'll go back, because we have a process in place as relates to parent complaints and parent concerns. But we'll go back, like you said, and look at students, and then add on the vendor. But we have an email, actually, that our parents use if they have school concerns at apslearns.org, and it goes to our executive directors of school leadership. And if it's a concern outside that particular department, then they will forward it to that particular director. But concerns from the schools go first to our executive directors of school leadership.
Okay, I think maybe we can talk about it a little bit more. Maybe you guys can bring that to the committee, and we can kind of look at it and see the process, and I think that might make it a little more comfortable. People understand what the process is. So if we say, here's what student referral, here's what you do if you're a teacher, here's what you do if a vendor, so they would understand that.
And we've had students use that particular process as well with our school concerns email address. But I like your idea about actually having a place on the website that says, if you're this person, click here.
Right.
Just to give more guidance and let people know that we do want to hear from them and help address whatever their concerns are.
Right. Madam President, you have something else?
Yeah, no, thank you, Ms. Carter, and you, Vice President, addressed what I was saying, because we know these systems exist, but I got emails, text messages, calls where it's not working, like into that level, or had an executive, the principal hasn't gotten it, like didn't know about it. It's not that building level a concern. So that way, if it's something that we can access and click on, like, oh, it's a grievance at this school, this teacher cussed this kid out, and the parent was up at the school. The parent ain't just get kicked out. The parent got kicked out because they came to see about this disrespect to their child. And all we have is that we have a non-trespassing order on the parent, but not all the backstory about what happened. When things like that happen, if we can just click, to your point, like something from the website to see this is the grievance. We see executive director of early education is investigate. It's on their desk. Okay, cool. We see where it's at, and so we know that it's being. We can tell the parent, "Oh, I'm aware of that. I know the right department is handled. I did see that." Or let me get back with you, and I don't have to wait or email you to call you. I can go right to that system, click, see that it was filed, and know that the executive director is aware of it, or they don't know. So let me make sure that I follow up. We're in real time, because sometimes things get lost, and people are told that it's been brought to central office, and then come to find out it has not. And I'm just saying that from a firsthand experience, because things have been shared with me from parents at building level or even teachers. And when I come to an administrative, to this office, and I say it, there are people here who were not aware, but when they became aware, it was handled. Mm-hmm. So that's why I'm trying to be adamant on that. Thank you.
I think that would include our whiteboard again, Madam President, that we can see what's happening in real time. A young lady had a question or comment.
What happens now if the vendor has a problem? Like in the now? What happens now if a vendor has a problem? Like now, there's no policy for right now. Mm-hmm. So what happens in the now?
So
Go ahead, Pastor.
So that's what we're talking about, and so it probably won't happen right now, and so the process is what you did last week or the week before. No, but we will get a policy. We will make sure we get a policy, and if there's something that's happening right now. That was a good hit, though.
May I ask that in the absence of the administrative guidelines, that all concerns be directed to me personally, and then I'll be able to quarterback them to the necessary parties to make sure they follow up.
Okay.
Okay?
Thank you.
You're welcome.
All right, any other questions on this particular policy? No more questions? Okay, next.
Next, we have our electronic equipment. Haley's going to speak to this. There really were no specific changes other than we did spell out, we had PCD in that last line, and we did spell it out, personal communication devices, policy 5136. And I believe there was a suggestion to add the actual wording from the policy. And Haley's going to speak to why the committee felt like, you know, we have to be careful with adding wording when we refer to policies in a policy. Go ahead.
Go ahead, Haley.
Thank you. As Ms. Carter just stated, there weren't really any major change besides some grammatical issues that were fixed within this policy, including this personal communication devices being spelled out instead of referred to as PCD, which was confusing. Reverend Harrison had suggested that we input policy 5136 into this policy. Pretty frequently, we have policies or statutes that will reference another policy. The issue when we start to input policies into each other is they become cumbersome and they do not change together. So if we had a change that was to the personal communication device policy, it's just as it keeps things a little bit cleaner and a little bit tighter to not input other policies into others every time we reference them. I think that was the only problem that this committee had, and that was a consensus that we came to in our internal committee with the administration. And I don't believe that there were any other issues at that time with this policy.
Pastor Harris?
So I wasn't asking to put the policy in the policy because there was only two sentences that related to. So when it says, when it referred you to another policy, and if there's only one or two sentences, then instead of sending me from this policy to another policy, then just put that part, whether you put it in a footnote or you put it somewhere that is accessible to me. So that was my, that's what I was referencing, not the whole policy in the policy, but whatever you're referencing of that policy, make a footnote. So I'm not going from a policy to a policy and then coming back to this policy. There was only one sentence in there that related to this.
You remember what sentence that is, Pastor Harrison?
No.
Or you want to get it for her later and give it to her either way?
Well, the sentence, you know, at this point is really irrelevant. It's the practice of, if I'm going to reference this policy, if I'm reading this policy and I'm going to reference another policy, then let me know the part that you're referencing. So I'm not saying put that whole policy in here, but this particular one, because if you read this one, it says, students shall not use personal communication devices, possess electronic equipment or devices on school property or at school-sponsored activity without the permission of the principal or as referenced in the personal communication devices policy 5136, okay? So when I go to 5136, it lets me know, because if I read this, I'm thinking, okay, well, they can't film at basketball games. They can't film at sporting events of any kind, but the policy that it references says that they can. And so that's the portion that pertains to this policy. So if there's just a footnote that says, except for as prescribed in policy 5136, instead of telling me to go there myself, just make a footnote that that's what it says, that I can. That's the exception. It's reading one policy instead of reading two.
Right. Think about that, Haley, and what he's saying. I think I have an understanding of what Pastor Harrison is saying, is that whether it's in bold or we just say this is referenced in such and such policy, so no one has to really go and go to this policy for one or two sentences in another policy. Is that correct? Okay. All right. Well,
Does she understand what
I do understand what you're saying, Pastor Harrison. I would have to take a look to see how much language. I think when we reviewed this, it was like a pretty decent. This was the way to keep it clean. But if we can see how we can pull that language from the personal communications devices policy. I think the larger concern is more so in terms of when things get updated and when things change, that they will change together so that they won't conflict if one policy is changed for one reason, and it's a quick change. When we get into putting words in policies, we just don't want to create a conflict between the two policies. So that was the reason for the recommendation, but I understand what you're saying.
Yeah, Mr. Chair, and I think sometimes we do things for expediency, but it's more convoluted in the end. So there is an exception to this, okay? So you can film at basketball games, football games, cheerleader competitions. And so in those types of things, to be slower and be clearer, except when you're at this event, or except as authorized by the schools, and that's where the administrative guidelines come in, that you can take your phone out, and if you're at a basketball game after hours, you can, take pictures or whatever. So sometimes we want to keep it clean, but it becomes more cloudy. So if we're going to change a policy, I'd rather change it to make it cleaner and make it more user-friendly, not for us, but for the parents that reference the policy, that needs to read the policy.
Understood. Thank you. Is that the consensus that we bring this back with a new iteration?
Yes, I was going to ask, come back the next meeting, so give us maybe an example or something to show that how we're going to do this, and that way we know it will be done in all the policies moving forward. Okay, and that way we can discuss it a little bit more if we need to at that time. Okay. Any other questions on this policy, electronic equipment? All right, let's move on.
Next, before we move on, I want to go back to vendor relations. Were we ready to send that on for a first read, or we want to take that back and look at the first line, or were we going to address that in administrative guidelines?
We have time, so we can keep it
On discussion?
on discussion, and then we can, once we get it ready, then we can move on for the first reading and then move into the second and third.
Okay.
This is not one of the policies that we're in a rush. Okay, so we have time for that one. All right. Okay.
Electronic equipment, we'll go back and we will look at adding the wording to this one. So right now, the only one we have for a first read for right now is the nepotism policy. Next, we'll move on to the independent contract operator and service provider policy. The committee went back and looked at the original policy that was written by Board Member Molinar, and we did go through and added some nuances from that. Again, it didn't change a lot. We did reference Ohio's Public Records Act under number 6 on the back as it relates to compliance and oversight. And then as we continue to talk more and more about this particular policy, the committee then began to talk about would this best live in administrative guidelines under vendor relations, because each contract with an independent contract operator or a service provider is different based on the service that's being provided.
Any questions?
I have a comment. Same with the in this policy as far as the a policy or a procedure of grievance.
Right, and I think that's where this would live.
Yeah. Well, I guess I'll speak to the administrative guideline part of it. I think I think this is a policy by itself, and then the administrative guidelines feed from the policy. Something that is this important, it's something that we use this often. And certainly when we update administrative guidelines, I think that this is something that I would like to see us kind of move a little slower and make sure we get it right.
Mr. Carter, are you saying this will be part of administrative guidelines to the vendor policy, this piece here, or this will still be?
I can't remember, I don't know if you remember why it was suggested that maybe this be administrative guidelines. I know that Board Member Harrison is saying that it should definitely be a policy, but I'm going to have Haley, just since we're in discussion.
All right, go ahead, Haley.
Yes, so, and I don't know, Ms. Volk, if you have any comments as well. We'd appreciate your insight, but for the reasons that Ms. Carter stated, that because the contracts are each different, that this would serve as an administrative guideline as opposed to a policy. I don't think that necessarily means it cannot be a policy, but Ms. Volk, do you have any comments?
Our original thought was, and to me, to Pastor Harrison's, 6460 is the policy. If we do it as 6460.01, it is a sub-policy. It's not an administrative guidelines. And then the dispute resolution we're trying to put into this could be part of this part of it. So I'm not saying it's not a policy, but to Haley's comment, these independent contracted service provider contracts are also different. They could be a minimum of $1. It could be multiple dollars involved, and they get very, large in the service, depending on what you're looking for. There are some of your service contracts that deal with, not, as an example, your transport is your occupational therapy, your physical therapy, your language therapy, when we do not have enough or is very specific to the child's or student's needs. So that's why we were saying it's probably still 6460 is the main vendor relations policy, but 6460.01 was a sub-policy under that. It's not that it is an administrative guideline.
Pastor Harrison?
Thank you, Mr. Chair. The reality for me is, we still are a service organization, and we deal with taxpayers' dollars. So we're spending taxpayers' dollars, and we want to be not just efficient from our end. Sometimes we can't have everything. We can't make all of the rules and then interpret all of the rules. So we want to be user-friendly and we want to be fair. I think that we need to allow vendors the opportunity to, whether it be appeal or bring in some sort of grievance, and it needs to be clear so that we can look at it. And if they come in and they say, okay, well, man, hey, man, you on step 7. You still got to go back to 1 and 2 because you may be able to resolve it at 1 and 2. But we don't have anything clearly that shows that. And so when whatever policy we're doing, that we're dealing with vendors or we're dealing with anyone who is, we're giving them taxpayer dollars. We need to be able to not just do it in an administrative guidelines, because again, administrative guidelines are arbitrary. They become arbitrary depending on who's reading them. A policy is more concrete, and it holds us accountable and the vendor accountable. So I would just like to see that as a, yes, ma'am. Oh, I'm sorry.
I would just like to add that the administrative guidelines really should tell us how to carry out the policy. So they should not be arbitrary. It should help hold us accountable to the policy, because it goes into detail saying these are the things you have to do to make sure you're doing this policy. Haley, you can correct me if I'm not right.
Yeah, and that's one of the things I'm going to say this on the record. I do like administrative guidelines. I think most people should have administrative guidelines because it's part of an operations manual. And when you talk about operations tell you, here's what you're supposed to do, here's the step by step. And so if our administrative guidelines are telling us step by step, we should do that. If this is going to be an addendum to the other policy, then we could add the dispute piece under there as well as the administrative guidelines, I think, if so everyone will be clear. I don't want to get messy either, but so we can be clear of here's the policy, here's what's going on, here's the dispute if you need dispute, but here's the process, the administrative guidelines on how you go about doing the process, the dispute. So is that clear enough? I don't know if it is. Please let me know. Anybody? Pastor Harrison?
And I'll keep going back to the policy.
Right.
The administrative guidelines tell us how we should do the policy, how the policy should follow. But again, we need a strong policy. And so we won't get away from the policy, whether we want to carve this part up and move it to this. We won't get away from a sound policy. And then how are we going to fulfill the policy? Trying not to commit things to a policy, I personally find that troubling, and especially when we are using taxpayers' dollars.
Right. So, Madam President, go ahead.
Yeah, I think that's a moot point. Ms. Falk said that 6460.01 will be a sub-policy. It still would serve as a policy, not administrative guidelines. She said it like 3 times,
right,
that this is not administrative guidelines, that it still would serve as a policy, correct?
Yes.
So we know what is being described is not administrative guidelines, but a part of the policy. And then on top of that, as Ms. Otley has stated, those in Chair Alexander, that the administrative guidelines and the grievance part will come as part of, that's the add-on part when to use the step example. So it's clear to me, as I said here, and this keeps going around, that this is going to be a part of the policy, and then the add-ons is the dispute and to shore up those administrative guidelines is a dispute process and administrative guidelines.
Yeah. Pastor Harrison, go ahead.
Yeah, it's not a moot point, and it wasn't clear to me, and it went around and around, and 3 different things were said. So I'm going to bring it back to whether it's a sub-policy, it needs to be a policy.
Thank you.
So question, I'm going to bring this up, just a comment. This piece here, since it's part of the subcontract, can this be part of the policy, that policy itself? Then you can do the dispute piece, and then you can also do your administrative guidelines attached to it. Can we do that, or do we need to have another policy and then do the same thing with the dispute and the guidelines? That's something we may not have to answer that today, but maybe when we come back at another time too, before we move this policy on, to come back and say, explain it so we can get a good understanding and that we know that we have the policy or the sub-policy or this combined as one policy and it has administrative guidelines to go with it. Okay. Yes, Ms. Otley?
Just one final thought to try to align with what I'm hearing with Board Member Harrison. So in the policy, it could reference if there's a concern that they can that they can have a way to address it. But how to address it wouldn't be in the policy.
Yes,
it would
ma'am.
be in the guideline.
Yes, ma'am. That's exactly what yes.
Okay, any more discussion on this here? All right, let's move forward. Time is ticking.
Okay, so the ICO policy, I think the committee understands that we're going to keep this as a policy, not move it to administrative guidelines. We will keep this in discussion. Next, I'll have Dr. Lash come up to talk about the Parents' Bill of Rights. And I believe that we don't have any other significant changes to this from the last time, and we believe we're ready to move this on to first read, but I'll let Dr. Lash take the lead on this one.
Okay, yes, that is correct. Good evening, Chair, President, Co-Chair. Interim Superintendent, Chief of Staff, Attorney. Good evening. Wanted to get everyone. So we, I believe last month, went through the Parents' Bill of Rights, and I'll just kind of walk you through it again. It starts with the fundamental right of our parents, to know what's happening with their students' educational experience. And so you'll see that it defines age appropriate and developmentally appropriate, because where it pertains to sexuality content, it'll use those terms. It also talks about a student's mental, emotional, or physical health and well-being, what some of the components that are included in that definition. So when you see those phrases, you kind of have the context behind it, and then sexuality content. So the first section, again, just really talks about for students that are in grades kindergarten through grade 3, that there is no instruction that contains sexuality content, but for any sexuality content, ensuring that it's age appropriate and developmentally appropriate, and that prior to that instruction, families would have the right to review those instructional materials. The next, any questions on that section?
Any questions? Nope, continue on.
Okay. So the next section talks about mental, emotional, physical health, or well-being, and essentially that if there are any substantial changes in the student's services, which include counseling services or monitoring related to a student's mental, emotional, or physical health or well-being, that the school will promptly notify the student's parent, and that information will not directly or indirectly be withheld from parents, again, regarding a student's emotional, mental, physical health or well-being. Okay. The next section, procedure for authorization from parents for health care services. This speaks, and you see that we did click the box there for providing an annual notice. So this will become part of our annual notification of items to families. But this section is making sure families are aware of the services, health services that are provided in the schools. And that before any health services would be provided, that authorization would have to be obtained from the parent. And then there's also, I know there's been conversation already this evening about a process resolving parental concerns, but this section in this policy is germane to the topics in this policy. So any parent concerns around sexuality content or health services, anything that's related in this policy, that there would be a protocol or a process for families to file that concern in writing to the principal. The principal would have 30 days to resolve it. If that resolution the parent does not agree with, then there would be another step to the superintendent or the superintendent's designee, and then so on. So there is that is outlined there. And then the final section in this policy is about the right, not the final, I'm sorry, but the right to inspect instructional materials. Again, this pertains to sexuality content. And then the last section, the right to inspect technology provider contracts.
Okay, any questions? Pastor Harrison?
And I asked the last meeting, the outside providers, what comes to mind is Red Oak or minority behavioral health. We don't have anything to do with them, but because they're in our buildings, do we have any responsibility based on their services that they provide?
Right, and the services, you're right, you did bring this up last time. The services that those organizations provide, the parent would have to open for services, and so there would be that communication.
Yeah.
That would not happen outside of a parent authorizing that to happen. Is that?
I guess what I'm saying is we don't bear any liability from the services. I'm assuming that they're mandated by their code of ethics, but because they're in our building, we don't, or do we incur
Have liability for their
based
services.
on this bill?
And so, yeah, I'm going to look to
Yes, that's a good
Ms.
question.
Folk.
Ms.
Yeah.
Basically, what happens, if Wanda was my daughter and I had asked that Minority Behavioral Health work on a contract to service her, but how this came about was we wanted to do it during a regular day, not after the office. So the contract, if I do that and you are the provider, you bring the contract to, now Haley's the principal, and you bring it to the school. You're asking for you to help Wanda while she is in school, and it becomes the principal's determination if time is available in the schedule, because it does not come out of core instructional time. To your point, they have their mandates on their contract to provide that service to the student, and all we are is providing the space.
Are we held liable?
And we are not held liable for what they do because that is a contract between the parent for the student. They are just in the space. It's just like the building that Minority Behavioral Health actually houses their offices in is, if it is owned by some other company other than Minority Behavioral Health, it isn't liable for them at that time. And that's how it became created. Okay, so you are there to provide the service under a contract that releases the parent's permission to allow you to service during the day.
President Jackson.
Member Harrison, thank you. That was an excellent question. That's to have me dump into something a little deeper. Now, I've seen Red Oak on our agendas.
Yes,
on
there
our-
are some agreements that you approved, and it started last year, where there are specific contracts for them to do specifics, but it may not be an individual contract with Wanda.
No, I understand that.
Oh, I'm
but
sorry.
To Member Harrison's point, I mean, I don't want to, I'm going to say to my point, because when Member Harrison asked the question, which I thought was a great question, I took it generally that these people that's in our buildings rendering these service, do we have any liability? And so I know you did the example about the individual child, because parents can have counselors, crisis management, come into schools, and then we sign off as principals, administration during their lunch break. They can sit with kids or something like that if the principal decides. But I'm talking about the bigger scope where we have certain services being offered in our building and we see these on our board agendas. Are there any liability to that? And then I want to put a pin in that. Are we liable for that? Are we tracking, Member Harrison? Is that kind of, okay, then my second part is to the point when you use Dr. Lash, for example, and you said they're just using a space. The parent is granting permission, and the principal is finding a space.
The principal does not, if they cannot find the space during the time or not, that doesn't exclude, we have the right to say, we can't service you during the school day.
No, I get that.
Okay.
You didn't let me finish my statement,
I'm
so
sorry.
that's why you don't know what I'm saying. So what I'm asking is, if that was to be done, when we talk about using space, right? So say a parent comes in and the principal agrees on the spacing between these hours of like a period of, like if we say cheer coaches with cheer competition, when we were talking about the use of space, and if you had a teacher, do y'all see what I'm saying? Like the example, if you use that, if the principal is okay and say, we have this space available from 3:30 to 4:30, it's a study hour, this space is open, and so these kids cheer, it's available. So for competition in this window until 5:30, they can use this space. Are you saying then the principal could say to that coach or that, the space is available and we will allow you.
I was talking during the school day only, from the hours, say, at an elementary from 8:30 to 2:30.
Oh, okay. All right. Thank you.
So I want to comment on that too. That I work with a lot of these organizations. I think from my recollection of it was in the past, and I assume this is still now, that these individuals, I've used Red Oak since we talked about Red Oak. Red Oak has a contract with the parent, and the parent is saying it's okay for them to come into the school to render services to my kid at a certain period or a certain time, well, whenever they have available time for them to come in. We're not responsible for anything that goes on with that kid, what goes on the counseling, as far as counseling with the kid and the counselor, because they're not ours. That's between the parent and the agency. Okay, and only part that we would be, I'll say, liable probably is that if something was going on, happens while they're doing counseling in our building to a kid, that's when we'd be liable, correct?
That would be correct.
Okay, so otherwise we wouldn't be liable for anything else.
That is
Just want to make
correct.
sure that's correct. Okay. All right.
And the service is done during the school day.
Okay.
That's how this got started.
Madam
So we
President?
do have liability.
If
That's what the question
Yeah,
is.
there is a liability. I assume, and I'm let them answer because I don't know for sure, but we would have liability if this individual came into council, say they come into council, Bruce Alexander, and they come into council me, and something happens between me and this individual during that time, then that could possibly be a liability on us.
You'd have to prove negligence, that we knew about it in order for us to be liable, and that doesn't usually occur. All we would do, and I'll give you an example. You could have an outside organization feel that something happened. We wouldn't have known, we just rented the space. So if we're not proved negligence or had knowledge that we would be negligent, we are not usually liable.
So, okay. Pastor Harrison and Madam President, okay.
Okay, so I want to go back to the Parent Bill of Rights, and I guess that's what I'm looking at. Okay, so my child tells someone from Red Oak, hey, I'm feeling this kind of way, and I find out I'm mad at Red Oak, but you told him in the school during this school day, and so if I read the Parent Bill of Rights, and I guess, are we indemnified from whatever they talk about, whatever happens? They're in our building, they're on our time, they're using our space, and we kind of go back to the intellectual property, time, space, resources. So all of this counseling is going on in our space during school hours, during school time. The child was transported to school on the bus, child going home on the bus. The child is in our care. This Parent Bill of Rights, are we responsible for any of this reporting based on the conversations occurred at school? And I guess that's maybe I'm not saying it right.
No, I think
Well,
he is.
Yeah, and it sounds like we might have, that's why I keep looking at Attorney Kepchar, we might have to have some additional kind of conversation, because I heard two things in Mr. Alexander when you brought up like what's happening in the confines of the counseling session versus something happening in the context of like we're in the building,
Right.
Those kinds of things. And so we might need to figure out those nuances, but then I hear like a larger of any of these service providers, what's our
In our
responsibility?
building.
Yeah.
And this bill was intended to make us mandatory reporters.
Well, we are.
Well, I mean, you guys are in some
Right,
areas.
okay.
Okay, but this bill was intended to make the school mandatory reporters of anything sexual. Well, we know why it was intended. I mean, it doesn't read like it was, but okay. My son is not feeling like my son anymore, and he tells one of the counselors how he's feeling. Okay, the school, do we have any responsibility in reporting because it happens with him and the counselor, him and the outside? And I guess that's the only thing I'm asking.
Yeah.
Do we have any responsibility?
Well, and again, I think we have to have some more conversation, but so some of that conversation probably is protected with the counselor and the student.
Yes.
And so if the student shares something with the counselor, just like you talked about their code of ethics, just like we're mandated reporters when we are aware of information or what have you. So as a counselor, depending on what's reported to the counselor, they likewise would have expectations around what they bring forward. But if they're in a counseling session that is protected between that counselor and the client, I don't know how we would know information to report unless I'm not following.
Ms. Carter?
That's a good answer, yeah.
Go ahead, Ms. Carter.
Oh, so I'm just wondering where you were getting at as relates to if they're in a session one-on-one with their therapists are mandated reporters as well.
Right.
Do they have to tell us that they did a report to CSB? I don't know if they have to disclose that information, but more than likely we would know, because then they would be contacting us to get more information from the school if the report is substantiated after they made their mandated report.
And I guess I'm just speaking of this particular parent bill of rights. So I mean, I know I don't know the whole CSB process, but that process of, their investigation, I'm just speaking of this parent bill of rights. And maybe it's a conversation with Red Oak and Minority Behavioral Health. Maybe it's something that the school says, hey, you know what, you have to sign this release that we're not responsible for what happens in the counseling session, but they're using our building, they're in our space. And so I think we need to make sure that we're not responsible as a reporter, not just if we knew, but should we have known.
Yeah, and let's get more information, let you guys come back with that. I think, and I'm going to say this, Pastor Harrison, I think that if that happens between the kid and that counselor, between them, now if this kid tells our counselor something, now our counselor has to get involved, because now they've said something to our counselor that can be harmful, or something needs to be reported by our school counselor. But if not, then I don't think our school counselor, our school period, has any responsibility. But let's please don't hold me to that. Let's check with legal to make sure we're right, and then come back and let us know.
Yes.
Okay. Ms. Otley?
I just wanted to add a layer that we also have that's called the access application, and that's how different vendors can get access to our students. And part of that lives with Dr. Lash's department, especially if it's mental health, with Dr. Merkel and Yvonne Culver.
Yes.
So there's an application. So they've also, the liability for us is that we vet them also before we just give them exposure to our scholars. We make sure that they're qualified, that they have the appropriate license and things like that, and then that they're on this list. And then the principals know, okay, because they're on this access list, if a parent asks for the sessions to be held at the school, I have permission by the district to allow it to happen at my school. If the provider is not on the list, they should not be hosting any sessions at the school. That would hold us liable.
Thank you, Ms. Otley. Okay, thank you, Ms. Lash. Let's do one more, because we are past our time. Let's do one more, and then we'll have to bring the others back for the next meeting.
So we'll do the first Neola update, and then we'll put the other one back on next time. So this one is purchases. Neola updated policy regarding purchasing and bidding. And Mr. Leonard, were you going to come up and talk about this update, or Deb was going to come up and talk about this particular update? It's just several of them.
Didn't put this one up, the one with the...
You didn't put up 320?
No, only the current policy, not the... in the packet, though.
Yeah, we have the paper copy.
Yeah, let me see if there's a way to it from here. I thought you said clicking wouldn't work. Oh, there it goes.
There it goes.
Okay, good.
Okay.
And then you just scroll.
Yeah, okay. So you have a copy of the original, and these are the updates for Neola. It changed 6320, and it's now called, instead of just purchases, it is purchases and bidding. They have gone ahead and taken the word quotations and bids out and replaced it with price quotations for items not required to be competitively bidded, because there are certain items you are not required to competitively bid. They had, excuse me while I try to get this to come down. Okay. Oh, yeah, there we go. So it was pretty standard, which has been around for a long time. As you can see, as you go through, there are limitations as to what you are authorized to do. They discuss the then and now certificate, which is an operational procedure, and basically its amounts less than $25,000 may be paid by the treasurer upon completion of a then and now certificate. A super blanket certificate is another one that they can go ahead and also complete, and those are standards. This is where it started to change. When you got after it was contracts for development improvement, it's now under the competitive bidding. And the area that you will see is a change in the revised code, and it has to do when the board determines to build, repair, enlarge, improve, or demolish a school building. So you're really into construction at this point. The cost of which exceeds the amount to be determined and published by the Ohio Director of Commerce. The drafting note is, as of October 24th of 24, they've increased that from $50,000 to $75,000. And it allows now a new nuance to it and automatically increases each year by 3% thereafter. This allows us to have the flexibility to know that, as an example, if the revised code says $75,000 and you get 2 years from now out of that, beyond that, you could then take that $75,000 and multiply it by 3% for 1 year and 3% for the next year. So as an example, the threshold then for bidding becomes, say, $77,000, $79,000. And this allows to keep up with the actual standards that are in the construction. So that was one of the updates. And as we started actually working on this last fall after the legislature approved it on October 24th of 24. That was the only change to it. It all remained the same under that section. It was just the amount and the fact that you could do this. The soliciting of bids actually stayed the same. And the awarding of bids stayed the same. So as an example, it talks about the purchase of school buses and certain other motor vehicles. The reason these are listed is they are considered items that will be longer than 5 years. So this is why they are put out there. It also tells you what you can do with a lease and purchase agreement. Some districts, as an example, do lease their buses. Akron has certainly purchased them over the number of years because we are able to maintain our fleet. Then it gets into the quantity of purchases. It did not change. The requirements, it was just a grammatical change. It went from a she shall check, it's to they shall check whether the proposed purchase is subject to bid. And again, under C, it is strictly a grammatical change. The reverse auctions did not change. Now, to Reverend Harris's other comments, you get into procurement using federal grants, you will have a cross-reference. And the cross-reference is the policy that we're not going to look at tonight. It's 6325. But that's always been there because you basically do your purchasing with your own general funds, but there are more detailed requirements for the use of federal grants monies as to micro purchases, macro purchases, and others, and we can go over those again. But those are the only changes. And the last time that we actually had this vetted and updated was 2019, and this is the most recent update from Neola in 2024.
Okay, any questions? Any questions? Ms. Carter?
No, I was going to say, if there's no questions, are we okay with moving this to a first read, or you want to keep it in discussion?
I think we can move it for a first read. Go ahead, Pastor Harrison.
Oh, I was going to ask, I didn't have a question. Well, I do have a question. I was going to ask if we could move it to the next meeting, because there is one part of this that I want to get clarification on, and it's the awarding of bids. I just want to get clarification on that section, Mr. Chair. That reads, the board shall approve all contracts resulting from competitive bids prior to being awarded. The board reserves the right to reject any or all bids. And that's a point of question based on something, a contract dispute last year. I just want to get a clarification. If we can just move it to the next meeting.
We'll go ahead and move that to the next meeting, and we'll clear it up next meeting, and we'll move it into the hopper to get moved forward.
Yep.
Okay.
Thank you.
That was it on our agenda,
Okay.
and then we'll bring the other procurement and purchasing policies back at the next meeting.
Perfect. Perfect. Is there any other questions, comments, or concerns before we adjourn the meeting? Anyone have any questions, comments, or concerns?
Mr. Chair, very
Yes,
quickly,
Madam
as we
President.
land this plane, I just want to reiterate the fact about those policies, the vendor policies, and that they are two policies, and not the additional administrative guidelines, but we're working on the policy and the grievance portion to where they can grieve, so that we can also not just cover the administrative portion, but the people that we're working with and who we serve, so, which the policies protect as well. And that grievance portion, I just want to re-emphasize that, since we've been waiting some time.
Okay. Let's make sure we bring that next time, too, so we can get that taken care of, if we can. Okay. Anything else for the good of the order? Yes, ma'am. I'm going to say my comments after the meeting for you. All right, if not, that's it. We'll close the meeting. Thank to everyone who was here, those who participated via TV. Thank you. Everyone have a good evening.